Hi, and welcome to the Brisbane Professionals Podcast. This is a podcast brought to you by SMS Law, going through the legal secrets that will benefit you and your clients, as well as having a little bit of fun as we go. This podcast is designed to educate you on, number one, complicated legal terms that we will explain in an easy to understand manner. Two, to understand why you do things from a legal perspective in your business. And three, to help you develop a plan for the future success of your business. Our mission is to help empower small to medium-sized businesses around the world to get access to legal advice so that they can help build their communities and make the world a better place. Did you know that any business owner is on average 7 months away from losing everything? That is the average time that it takes from a successful business to fold when an aspect of their business is not set up correctly. This podcast is all about empowering you and your business with knowledge and tools to ensure that that doesn't happen to you or to your clients. Let's begin, shall we?
Hi, everyone, and welcome to the Brisbane Professional Podcast. My name is Craig Mason from SMS Law, and I have with me Jeremy Stratton from SMS Law. Please say hello to everyone, please, Jeremy.
Hi, everyone. I hope you're having a great day.
Indeed. Today we wanted to talk about copyright and the misconceptions about copyright. So we've come up with 5. There's probably more. But we don't want to go on for too long, so we're sticking with 5. Jeremy, do you want to kick off with the first one?
Yeah, so the first one is, it's not a big deal if I use content without permission. I won't get in trouble. This is a big misconception. People think that they can just get away with using other people's copyrighted material. So copyright forms in a creative work that someone makes. So if they write a blog post, if they write a book, if they record a video like we have here, the actual expression of the idea, so the writing or the video or a music or song, is copyrighted. But actually what we say isn't so much copyrighted. So using someone else's copyrighted material, like verbatim copying what they say word for word, is a breach of copyright, and it will get you into trouble. There are more and more programs that are coming out every day that can track copyright and look for whether or not certain articles that are on the internet or videos are breaching copyright. So it will catch up with you, and you will get notice, and people will start to investigate it. So it is a big deal, and make sure you don't just use it without permission. Craig, do you want to do the second one?
Yeah, the second one is, if I pay someone to create something for me, I then own the copyright. So this is, it does have a it depends section in this answer. So if, for instance, the content was created by, say, a staff member, and the work is created during their employment as part of the job, for instance, then the employer would own the copyright. If it's a content creator is, say, an independent contractor, then they'll normally retain that copyright unless there's something in writing that transfers it over to you as part of the agreement. So if you don't have an agreement about how you may use it, then you're usually only entitled to use it for the particular purpose as to what you've asked for. So that only, but you probably are not allowed to use it for other purposes because the copyright will remain with the original creator. So something to be careful of there. It's not a straight answer, and you need to consider employment arrangements, contractor arrangements, and whether or not there's anything actually in an agreement about whether it transfers over or not. So definitely something to think about. We've seen before people not realizing that it hasn't transferred over despite the fact they've paid a fee for something, thinking that that's theirs forever and they can do what they want with it, which is not necessarily the case. So be careful there. All right, Jeremy, what's the third misconception?
The third one ties into the first one that I talked about, and this is that getting permission is difficult. So you can use copyrighted material if you get permission from the person who created it and has the copyright in it. Just ask. At the end of the day, just ask and find out, one, whether they're comfortable with it. A lot of people are happy if you acknowledge that their work to be in there, and find out what they want. And often that can really work to let you use copyrighted material and really get over the fear that a lot of people have for doing that. As long as you're not profiting from someone else's work, usually they won't mind if you use their work, so long as they're appropriately credited for it. So Craig, the fourth one.
The fourth one, this is a pretty big one. If there's no copyright notice, it's not covered by copyright. So we're talking about the copyright notice, which is the little C with a circle around it, and then normally the copyright owner and the year. So that's a recognised signifier that a work is protected by copyright, and you can put that on your work, but it's not necessary for copyright protection. So copyright automatically applies to written and artistic works from the moment they've created, whether or not you have the little C or not. You don't have to put it on there to obtain the copyright. So a lot of people think that means that it's automatic, or having that C on there means something more than what it really does. It doesn't matter whether it's there or not. It still applies. Jeremy, the fifth and final one for today's show.
Yeah, so the fifth and final misconception is that as long as I cite my source, I can use third-party content in my articles, reports, and presentations. Now, this, again, can be a double-edged sword, because you are allowed to use it if you are using it and fall within one of the fair use exemptions. So if you are someone who studied at a university and did a degree, and you had to cite certain works in your degree material, your paperwork that you submitted for that, you will have known that you could do that. However, most people in that situation don't realise that they're able to do that by citing the fair use doctrine, which allows you to use it under certain circumstances. We're not going to go into all those circumstances. That's a very long and boring podcast. But just know that if you do want to use them and you do want to cite the source, you need to have a look at the fair use doctrines. And most of them are pretty reasonable in the circumstance. So you want to look for what's reasonable. And most of the time, if you think about what's reasonable, that's probably going to be fair use. But check it out and make sure that it is and will fall into fair use. And I think the biggest rule of thumb I can give you here is if it smells like it's not fair use, it probably isn't. So just bear that in mind as you're going forward. But if you do want to use it and you want to cite the source, you can do that, but just make sure that you fall within the fair use doctrine. Craig, I think that's it for today's show.
Yeah, very smelly misconception there, Jeremy, on the copyright. But that is it for us today. That's our top 5 misconceptions about copyright. Important to get it right. All right. Thank you for joining us. As always, please rate and review the podcast on whatever platform you're receiving it. If you'd like to keep in touch and get involved in our community, please like SMS Law on Facebook, follow us on Twitter, or connect or search for us on LinkedIn. We do, release other material and information throughout the time outside of the podcast. So please get involved. We'll be back next time. Thanks for joining us.
See you next time.